Hey, what's up? It's Ms. D, and we are going to finish up our discussion on civil rights with looking at important Supreme Court decisions that have touched on this topic. And to do that, we are going to focus most of our time looking at decisions handed down by the Warren Court. That is the Supreme Court, these justices before you that served between 1953 and 1969. And the Warren Court gets its name from the Chief Justice Warren. Okay, and then this is the makeup of the court. These are the justices that served during this period. You may remember too, we talked about at the very beginning of the year, I actually mentioned the Warren Court because we started the year looking at the Marshall Court. Remember, I said the Marshall Court was one of the most important groups of Supreme Court justices. Again, it's named after Chief Justice Marshall. That's where the name comes from. And these 9 justices of the Marshall Court, who served between 1801 and 1835, were very important because they're the ones that expanded the power of the federal government, right? They're the ones that set forth this idea that the Supreme Court was an equally important branch of the government, right? Because the Supreme Court had the right of judicial review. It was the Supreme Court that could determine whether or not a law or a governmental action is unconstitutional, right? That was the Marbury versus Madison case. And there's also McCulloch v. Maryland and Gibbon v. Ogden, all of them expanding the role of the federal government. And I said, you have to know the Marshall Court. The Marshall Court is known for expanding the power of the federal government. And I said, you could think of it as a big M and then the reflection is a W, because there's only 2 courts that you need to know by name. You need to know the Marshall Court, and the other one you need to know is the Warren Court. And that's who we're focusing on now. The Warren Court is famous for the fact that it is a very active court. It's a very liberal court, and this court, this group of 9 justices, are going to expand civil rights for many groups of Americans. They are definitely critically important to the fight for against racial segregation. They are the court that decided Brown v. Board of Education and Loving versus Virginia. We're not going to talk about those now because we've already talked about those when we looked at African American civil rights, but you guys should be familiar with those cases. Brown v. Board obviously is the one that overturned Plessy versus Ferguson and said separate but equal is by its very nature unconstitutional. And Loving v. Virginia struck down laws that found that marriages between 2 people of different races were illegal. It said that's unconstitutional. You can't have those kinds of limits. What we're going to focus on in this presentation is their decisions that involve criminal procedure, so the rights of the criminal versus the state. We're going to look at the issues of free speech, school prayer, and finally, it is the Warren Court that finds a right to privacy. Now remember, when we looked at the Bill of Rights, right, there are many rights that are just spelled out. Okay, there's the right to free speech, the right to assembly, the right to bear arms, the right. There's lots of those rights listed out in the Supreme Court. What the Warren Court does is, based on all of the writings, based on the Constitution, based on all of the law, everything written, they look at the Constitution and they infer a right to privacy. It is this court that says that there is a right to privacy. Even though it isn't specifically written out, you can infer a right to privacy, and that's one of their real critical and important decisions. All right, so let's start off with our look at criminal procedure. And, you got to remember, one of the biggest differences between a true democracy and a free country versus when you live in a totalitarian, autocratic state is the rights of people accused of crimes, right? In a totalitarian state, in an unfree country, one of the first things you see, the most common thing you see is, right, the secret police. They come grab you in the middle of the night. They throw you in jail. What did I do? None of your business. You end up in jail. You end up shot. You don't have an opportunity to try to prove your innocence, right? That's one of the most important keystones of, most important pieces of being in a free country. And it's hard because, by the same token, the state has a lot of power. The police have a lot of power. And they should, don't get me wrong. You need people to control for crime and stop criminal behavior. But at the end of the day, if once you're accused of a crime, there has to be a difference between an accusation and proof. You get what I'm saying? When you're accused of a crime, you have to have certain rights. You have to have the right to get a chance to prove that you didn't do it. Or else there's no difference between accusation and proof. That's really it's a keystone. It's a really important part of our country's freedoms, right? So one of the first decisions that we're going to take a look at is Mapp v. Ohio. And this has to do with the protections that you have under the Fourth Amendment to a protection against unreasonable search and seizure, because that's written straight out in the Constitution. In the Fourth Amendment, you are protected against unreasonable search and seizures. So the issue in this case was that the police came into this house and they had a warrant to search for what was it? They thought that this person was involved in betting, right? He did something. He suspected of a crime of illegal betting. And they come into the house and they do their search, and lo and behold, they find something that has nothing to do with betting. They don't find proof of the crime they're looking for, but they end up finding a proof of a different crime. And what happens is this makes its way to the Supreme Court, because the question is, look, are we going to allow police to just go on a fishing expedition? Oh, I suspect you of this crime, you know what I mean? And you use that, this one warrant to search for anything and everything and rip this person's life apart in hopes that you'll uncover some other random other crime. And that was the concern. And Mapp v. Ohio was like, look, if we're going to protect people against unreasonable search and seizure, we've got to put limits on a warrant. The warrant has to be specific. You need to bring that piece of paper, and the piece of paper has to be specific. Now, I will tell you, there are limitations on this, so don't get too excited here. There are a lot of limits, because what happens is one of the issues has been that what they say is that this idea of like inevitable discovery or good faith. If you're going in there on a fishing expedition, like I said, you're going in there knowing that you have a pretty weak warrant, but you're really looking for another case, but you can't get a warrant on that one because you don't have enough evidence. So you're trying to use one warrant to get you proof of another crime. That's not okay. That's still not okay. But if you're going in there in good faith, like you're really going in there to prove one crime, and you just happen to uncover evidence of a really massive crime, you should be able to use that. And generally, that is allowed. If you're doing something in good faith, if you would have figured it out anyway, if this evidence would have come to light down the road, you should have the right to use it. So this Mapp v. Ohio is more limited today than when it was first announced. This case, however, Gideon versus Wainwright, this is a really important one. And this is the case that said that everyone is entitled to an attorney. If you've ever heard that, right? If you can't afford an attorney, one will be provided for you. This is really important, because what happens is it used to be that, in states, they'd say, all right, fine, we'll pay for your attorney, you deserve an attorney, but only if you're accused of like murder or something where like you could possibly get killed. Like then we'll give you an attorney. But other than that, you're on your own. And by definition, that is just completely unfair. Do you know how expensive attorneys are? That's crazy. There's no way you would absolutely, don't get me wrong, we still have problems with this today, but the idea that only a wealthy person can afford to bring an attorney in with them, and poor people would just, anything short of murder, you would end up going down just because you can't afford an attorney. And so what happens is according to the Supreme Court, they were like, look, if it's a felony case, if it's any kind of capital crime, if it's something that it's like a major crime that carries like significant jail time, you have to give the person an attorney. You can't send them in alone. Because look, the Sixth Amendment, you have a right to counsel, and the 14th Amendment says you have a right to equal protection. You put those together, you have to treat everyone equally. If you only provide it if only a small segment of the population has access to an attorney because they're poor, because, they're rich, and that only that small segment, it's not fair to everybody else. And so this is the idea that they've really, and this right to an attorney has been expanded, actually, as opposed to the other one. This has actually gotten bigger. That today it applies to juveniles, that you can't have a little kid accused of a crime. They automatically get an attorney. That even misdemeanor crimes, so not felony crimes, even misdemeanor crimes, if they carry a jail sentence, you deserve an attorney. You'll get an attorney. If you can't afford one, the state will provide you. All right. And then, of course, Miranda v. Arizona. You should know Miranda rights, because you've heard them. If you've watched any TV that involves a cop, or any kind of if you've watched those TV shows like Law and Order or SVU, or movies with a cop in them, you'll always hear that thing. You have the right to remain silent. Anything you say can and will be used against you in a court of law. If you cannot afford an attorney, one will be provided for you. Do you understand these rights? Doesn't that sound familiar? You must have heard that. You must have. You have the right to remain silent. That must sound familiar. If you've watched TV, unless you have your head under a rock, you should be familiar. That is known as your Miranda rights. What happens is one of the issues is that you can have all these constitutional rights, but if you're not aware of them, if you don't know they exist, how helpful are they? What's the point of having rights if you don't know they exist? So, especially in the case of a criminal defendant, where you do have a right to remain silent. But if a cop arrests you, shut up. Don't say anything. Wait till you get an attorney. Wait. That's like the number one. Sorry, I went to law school. That's lesson number one. Don't keep your mouth shut. Because you can end up getting yourself in trouble. You can end up saying something because you're nervous and you trip yourself up. Next thing you know, you're going to end up in jail. You have a right to an attorney. You have the right to remain silent. Use it. And that's really what the Miranda case, the Miranda v. Arizona decision was about. That you had this person who was convicted of rape and kidnapping because he made some statements to police. And they said, you know what? He had this right to remain silent under the Fifth Amendment. He has a right to counsel under the Sixth Amendment. He has a right to equal protection under the 14th Amendment. It's to make things fair among anyone accused of a crime. We have to just remind them of their rights. So that's where your Miranda rights are coming. And if the police screw up, if they arrest you and they do not give you they don't read you your Miranda rights, you'll walk free. It's no joke. Now, here's the deal though. If you're not in custody, like if it's like a stop and frisk kind of situation, they don't have to read your Miranda rights. If they're not taking you into custody, if they're not holding on to you, and I'm just asking you a couple of questions, I'm just looking for your help, they don't have to read your Miranda rights. It's only after they've pulled out the cuffs and all right, I'm taking you into custody. Now you have the right to remain silent. That's the idea. While they're gathering evidence, they don't have to keep saying your Miranda rights. It's basically when they take you into custody. So before that, like I said, keep your mouth shut. Just a little free legal advice from somebody who's not a lawyer, by the way. I don't want to get in trouble for that. All right. The next case that the Warren Court decided that we're going to take a look at is Tinker v. Des Moines. Tinker v. Des Moines is about free speech. What happens is, take a look at that photo. You see these kids, right? They're your age. They were going to high school. And they were going to high school during the era of Vietnam. And so they decided they were anti-war, and they wanted to show their support for the anti-war protesters. So they decided to go to school with a black armband. The black armband that they're holding. It just has a peace symbol on a black armband, so they would wear it during school. It's nothing outrageous, not saying anything, not marching, not disruptive, just wearing this black armband. And what happens is the school basically said, you're not allowed to go to school with that. You're not allowed to wear that. They sent them home. They were suspended. They got in a lot of trouble for this. And they ended up deciding to sue the school. And it made its way all the way to the Supreme Court. And the Supreme Court said that students, that you guys, just because you walk into a school building does not mean that you lose your right to your First Amendment right to free speech. You still have your right to free speech. Don't get it twisted. You can't be disruptive. you can't use your free speech to a point where where we can't hold class because you're like, I have the right to free speech. So let me tell you guys all about what I did this weekend. No, no, no. No, you can't. No. That's not First Amendment free speech. You cannot stop me from teaching the class because you want to use your free speech to talk about, the latest, whatever, music video from friggin' Ariana Grande. No, that's not your free speech. But if you're doing something like, protesting in a way that does not interfere with the educational process, you're good. So, for example, I don't know if you guys remember, a couple of years ago, there was that March for Our Lives thing where students just quietly exited the building, and did this silent form of protest in a very respectful way. The reason you're allowed to do that is the Tinker v. Des Moines case. Engel v. Vitale. This one said that school prayer is unconstitutional. You guys remember, how every day, right? We started the school day, you put your hand over your heart, and then it's, we do the Pledge of Allegiance, right? And that's part of starting the day. What happens is right after kids would do this, the Pledge of Allegiance or before it or whatever, I don't know, this is before my time, but they used to basically say a prayer. They'd say like the Our Father or, whatever, Our Father who art in heaven, that kind of thing. They would literally say a prayer. And here's the problem. You're saying a prayer, and it was always, by the way, it's always a Christian prayer. Just FYI. It was, it wasn't like they had like multiple options. It was always a Christian prayer, and they would say it as part of the school day. And people said, whoa. Like, this is not cool. Like, we have, remember, in our First Amendment, right? We have a First Amendment. In the First Amendment, it's all about freedom of religion, right? And not everybody's Christian. People have different religions. And once you're doing this kind of school prayer, and it was like, well, you don't have to join in. Yeah, but if you're the only kid not saying the prayer, you're going to be the one standing out. You're going to be the one that people are going to whisper about. You're creating this kind of separateness to this person where it's going to carry in a negative connotation that if you're not a Christian, you're not one of us, you're different. It leads to prejudice. It leads to friction within the school. It's, that's not fair. That's not equal. So that was the idea, that they had to make school prayer unconstitutional. All right. Griswold v. Connecticut. This may sound familiar because you should remember that I talked about this one before I talked about Roe v. Wade, because this was an important one that kind of leads to it. And this was the idea that, like I told you, early on, even though the birth control pill was legal, it had been cleared as safe and effective birth control, in many states it was actually illegal to provide counseling, medical treatment, even to married people. So it was 100% illegal in Connecticut to ever provide information or the birth control pill to anyone in Connecticut. And so what happens is the Supreme Court says, listen, this is crazy. Like, you're not giving people access to birth control. Like, the state is deciding whether or not these adults can have the right to decide to use a medication that will prevent birth control, like that will prevent them from a pregnancy. The state is deciding, the country, the government is going to decide whether or not you get access to this medicine, that you get access to this information about your options. Is it really the state that should make that call? Does that sound right? Who should decide whether or not you're going to have a baby? I would think that's your call. That should be your call. That should be your individual call. And that's what the court said. The court said, look at the First Amendment, the Third, the Fourth, the Ninth Amendment. All of these things are about individuals having control over their own lives. And from that, they inferred and they created a new constitutional right, the right to privacy. That individuals should be able to decide things and make decisions about themselves and their own lives in private. And this was incredibly important, this idea of this right to privacy. And it's going to have real ramifications into many cases, and it's referred to in many other cases that come later, most specifically in Roe v. Wade. I mean, this is the big one that clears the way for that. But again, it's going to allow access to contraceptive and allow people to make that decision for themselves. All right. So before we finish, like I said, that was really the focus of the Warren Court. And as you can see, that's a lot of decisions. And all of them really expanding civil rights, like I said, for individuals. So it has a huge impact on our lives. But there are other decisions that also expanded civil rights. I'm going to take a look at them real quick. There was the New York Times versus United States. This one has to do with whether or not the government can keep information out of the news media, like whether or not the government has the right to censor information. And New York Times versus United States, that comes out in 71, says no. The government's right to censor information is very, very limited, that we have a much bigger right to free speech, and the newspaper should have access to that information. And we're going to look at that New York Times case later when we look, when I do my presentation on the Cold War. We're going to take a look at that because that comes out during that Vietnam War era. So we're going to look at that again later. Roe v. Wade, we already talked about when we looked at our civil rights presentation about women. Texas v. Johnson, this is the case that says that you have a constitutional right to burn the flag, burn the United States flag as a form of protest. That free speech includes the right to burn a flag. Other decisions that come out, not by the Warren Court, so these are by other courts, but these are going to do the opposite. These are going to narrow civil rights. These give you less freedoms. They're going to limit your freedoms. So one is the Regents versus Bakke. This is the idea that you may remember we talked about the fact in our presentation about the civil rights of African Americans, we talked about the affirmative action, right? And that because of all of the systemic racism against African Americans, that they should be given more opportunities to access education and jobs and things like that. And that was what affirmative action was about. What this Supreme Court said in 1978, so it was not the Warren Court, it's a different court, but in 1978, the Supreme Court said, look, you can use race as a factor. Don't get me wrong. If you've got two candidates and you're thinking who would be best for the job and you want to use race as one of the factors in your hiring decision, that's fine. But you cannot use quotas. So you can't say, all right, we've got to hire 15 black people and the rest can be any other race. That's not okay. You can't have quotas. You can't use numbers. It can be a factor, but it can't be a quota system. You can't just decide beforehand how many people of this race versus that race you're going to take. So that was that case. New Jersey versus TLO. This is the reason why if you decide to walk into the school building and bring a knife or drugs or whatever, you're going to get searched. That's why the deans can come after you. There is a reasonable ground to search your stuff. The dean's office does not need a search warrant to go through your things, because what happens is when you leave home, the idea is that we are what's the legal term is in loco parentis. What that means is like in place of your parents, basically, in Latin, something to that effect. But it's basically like you're not at home, so your parents have kind of handed you off. You're all minors. Your parents have handed you off to the school. So we act as your parents. Now, look, my kids right now, if I think my sons are screwing up and they're coming home glassy-eyed or they're acting off and I think they're doing drugs, I don't need a search warrant. I'm busting into their freaking rooms. I'm going in. You're not going to stop me. Same idea, right? The school doesn't need a search warrant before they check your locker, before they check your backpack, things like that. That they can, if there's probable cause. I mean, they can't just do it just funsies, you know what I mean? Like, everybody, open your backpacks. You can't do that. But if there's a reasonable cause to suspect that you're doing something wrong, the school can look through your stuff. Hazelwood versus Kuhlmeier? I don't even know how to pronounce that, but the Hazelwood case. That's the one where, normally we talk about freedom of the press. Well, what happens is that freedom of the press does not extend fully to a school newspaper. School newspaper is a little different. New York Times, Washington Post, Wall Street Journal, that's different. Those are publications, fine. But when we're talking about a school newspaper, the idea is that the schools do have the right to limit what can be published in this newspaper. That that a school newspaper has slightly different rules because, again, it would be disruptive. It's part of the school day. It's that in loco parentis thing where certain certain items may be considered like inappropriate for discussion in that venue, whatever it is, but it is not a violation of First Amendment rights. That school newspaper editors have less freedom to write whatever they want than a regular newspaper, that's being sold out to the public. All right, and with that, we are done. Thanks so much.